It's second quarter, the grill's smoking, someone's yelling about the lawn, and then out of nowhere, are we getting a prenup? You can feel the remote slip off the couch and romance do a little sidestep. Welcome to Danni's Den. I'm Danni, and today we're going to make prenups and postnups actually useful for money, for kids, and yes, for keeping your game day rituals intact. Let's chat. Quick definitions. Plain language. A prenup is something you sign before marriage. A postnup is the same idea after you're married. Mostly they govern finances, who keeps premarital assets, how to handle debts, whether a business stays with its founder, and sometimes limits on spousal support. That's their strength, clarity on property and money. Their limit? They're not a magic wand for everything, especially not for deciding a child's future forever. I hear two giant fears. Is asking for a prenup unromantic? And will this even hold up in court? Short answer, asking is adulting, not doomsaying. And courts don't automatically toss agreements. They look for fairness, full disclosure, and that no one was pressured.
You might think a judge will rip up anything that smells unromantic. Not true. But if an agreement is shockingly one-sided or someone hid assets, a judge may set parts aside. Independent counsel and honest disclosure, two quick ways to make your agreement tougher to challenge. Now, parenting. This trips people up. Can you sign away custody? No. Courts answer to the child's best interest at the time of dispute, not to a promise signed years earlier. So permanent, absolute custody waivers are a red flag. But don't pack up your hope just yet. You can absolutely craft cooperative parenting provisions that support stability, routines, notice rules, mediation steps, framed as agreements to cooperate rather than permanent substitutes for court discretion. Short anecdote, I worked with a couple who fought about swapping Sunday custody when one parent worked irregular shifts. They added a 24-hour notice rule for swaps and a simple mediation step. It cut the fights in half and kept Sunday rituals steady while the kids were little. Those kinds of practical fixes actually matter in real life. They signal cooperation, help kids, and give judges evidence you were reasonable and child-focused if things ever get contested. Okay, negotiating tips, quick and usable. Start early, not between innings. Exchange full financial information. Honestly, use separate lawyers. And when emotions spike, pause and bring in a mediator or financial neutral to keep it fair. Want a short, immediate checklist? Bring these to your consult. Last 2 tax returns, 3 months of bank statements, mortgage or deed, and retirement account statements. If there's a business, bring a current valuation or recent profit and loss. Simple, concrete, useful. When you talk about parenting and routines at the table, keep language logistical. Who has morning drop-offs? Who has priority on Sunday afternoons? How much notice for changes? Concrete logistics beat abstract promises every time. Example phrasing: parents agree to maintain Sunday morning routine for the child and to provide 24 hours notice for any schedule swap. Disputes will go to mediation before any litigation. Short, specific, cooperative. Want a game day clause? Try, Parent A has priority for Sunday afternoons during the regular season, unless both parents agree otherwise in writing at least 48 hours before kickoff. That preserves tradition, but leaves room for real-world flexibility. You'll notice these samples avoid absolutes. That's on purpose. Courts like evidence of cooperation and best interest thinking, not rigid deals that ignore changing circumstances. Red flags to avoid. Don't attempt to block the court from revisiting custody. Don't waive child support. And don't accept wildly unequal financial terms without a good documented reason. And seriously, don't hide assets. If you want starter language to bring to a lawyer, say this aloud in your planning talk. We want an agreement that outlines premarital asset division, a plan for household expenses, and a mediation-first dispute process. We will outline parenting routines to support stability, not to replace the court. A couple of rhythm tricks to keep conversations human. Ask short questions, who keeps the recliner, make one clear goal per meeting, and end each talk with a next step. Gather documents, call a mediator, book a consult. 3 immediate steps you can do this week.
1. Have a calm, goal-focused talk about what matters most. 2. Collect the documents I mentioned. And 3. Schedule a short consult with a family law attorney to learn what's enforceable in your state.
Quick caveat, sample language and friendly promises are a helpful start, but they aren't a substitute for lawyer-reviewed documents tailored to your jurisdiction.
So here's the bottom line. Prenups and postnups don't kill romance. They can protect finances, support parenting stability when framed correctly, and even help preserve those weekend rituals that make family life yours. Be fair, be honest, and get counsel. Thanks for listening to Danni's Den. If you have a specific legal issue and want help, send a direct message or check the show notes to book a free 30-minute consultation. Subscribe for your weekly mix of law, love, sports, and pop culture. Let's chat.